So, welcome everyone to the third session on this opening day of the India Arbitration ADR Week, organized by the Mumbai Center of International Arbitration. This session is being graciously hosted by Clifford. So, thank you for that. What we will be discussing in this session is the 2019 amendments to the Indian Arbitration Act, and where do we stand with regard to them, and where do we go from there. We have, as always, a stellar set of panelists for you to hear from. They're all industry leaders, highly recognized in all relevant publications and the most recognized names in this region and the APAC. We have with us Mr. Kabir Singh, who's a partner with the International Arbitration Dispute Resolution Group of Preferred Chance. He's based out of Singapore, and he deals with complex cross-border disputes across the APAC region and has a focus on India and Southeast Asia. Welcome, Mr. Singh. We also have Mr. Nair, who's a partner with the Arista Chambers. He's an advocate in India and a solicitor advocate with high rights of audience in England and Wales. He's an expert in public international law and has been representing India in a number of investment arbitrations, and in fact has the distinguished honor of representing India before the United Nations. Welcome, sir. We have Mr. Percy Billimore, who's a senior advocate at the Indian Bar. He has extensive experience in international commercial arbitration, as well as arguing matters before the courts in India, including the Supreme Court. He's regularly appointed as an arbitrator by a number of leading international arbitration institutions, and he argues before courts in India and the arbitral tribunals as lead counsel. Welcome, sir. We have Mr. Rajendra Barot, who is a partner with AZB and heads the dispute resolution practice of the firm in the Mumbai region. He's acted for clients in numerous high-profile arbitrations, both in and based outside India. He's also acted for clients in investment arbitrations against India. So welcome, sir. We also have, and finally, we have Ms. Vanita Bhargav. She's a partner with the Delhi office of Khaitan and Company. She's been an AOR. She has a distinguishment of being an AOR and has 25 years of experience acting for clients in high-stake international arbitrations and commercial litigations before various forums. And thank you for joining this, ma'am. I will now, of course, leave the floor to Mr. Singh to moderate the session and take this discussion forward.
Thank you very much, Paresh, for that introduction. It was indeed an honor for me to be moderating the panel today with a really all-star cast of panelists, I must say. You've got the who's who of Indian arbitration, and I'm very happy that they've all accepted the invite on behalf of Clifford Chance to participate in the panel. Now, the panel discussion today, as many of you know, will focus on the sort of latest 2019 amendments to Indian arbitration legislation. Again, something that many of us can still remember, and to take stock of these amendments, really, and to see where we are and how far we've come, and perhaps how far we need to go. Now, historically, many of you will be aware that India's aspirations to become a major international center for arbitration have, in a sense, been hindered somewhat by their arbitration laws, sometimes the arbitration jurisprudence as well. Now, in an attempt to remedy this situation, India's arbitration legislation has seen significant changes over the past 6 years. Now, many of us will remember 2015 as being sort of a watershed in terms of the Indian arbitration landscape, when the Indian government made long-awaited overhauls to India's arbitration legislation, partly in response to a 2014 Law Commission report calling for amendments to the arbitration laws. Now, some of the key changes were designed really to remedy the shortcomings in Indian arbitration. For example, there were provisions for the granting of interim relief, Section 9, and collection of evidence by Indian courts were made applicable to international commercial arbitrations. Section 12 of the Act introduced greater clarity and detail on the circumstances affecting the neutrality of arbitrators. It sets out a list of circumstances in the 5th schedule, which gives rise to justifiable doubts as to independence or impartiality and require written disclosure from a prospective arbitrator. Strict time limits were imposed on the arbitral process. Under Section 29A of the Act, an arbitral tribunal had to render an award within 12 months. Again, this was probably a first in any jurisdiction that many of us are aware of from the date of the appointment of arbitrators. Again, this was extendable by a further 6 months. On the enforcement of awards, the amendments clarified that patent illegality as an element of public policy applies only to domestic and not international arbitration, and specified that Section 34 reviews should not be reviews on the merits. And then the bill also sought to amend Section 36 of the Act to provide that the mere filing of an application to set aside an award would not result in an automatic stay. Again, it was a tactic long used to delay the enforcement proceedings. Now, the amendments in 2015, I think many of us would recognize and agree, were generally well received by the arbitration community, both inside India and outside, albeit not without some controversy and some teething difficulties. I mean, there were many firsts that India sought to introduce in its legislation, but again, many would argue that given the state of affairs, that was necessary. Then in 2017, recognizing that perhaps some further changes were needed and some further tweaks would be beneficial, there was a high-level committee report chaired by Justice Sri Krishna, and they issued a report with recommendations to encourage the use of institutional arbitration in India and to promote India as a seat for both domestic and international parties. Now, on the back of that, somewhat, further legislative changes followed in 2019. Again, these are the 2019 amendments we'll be talking about, some of which were to be expected, but others of which somewhat surprising. For example, under some of the 2019 amendments, the courts were empowered to designate accredited arbitral institutions for the appointment of arbitrators. Again, slightly, surprising, slightly new, and again, not something that you would typically expect courts to get involved in. Again, there were slightly amended time limits that were introduced on the filing of pleadings and issuing of arbitral awards. There was an obligation that was imposed on arbitral institutions, the parties to the arbitration, to maintain confidentiality. Again, that I think was very welcome by many, many quarters. A new 8th schedule was introduced, setting out the general norms applicable to an arbitrator, although arguably it also in some views disqualified foreign registered lawyers or retired foreign officers from sitting as arbitrators, and again that was one of the more controversial ones. Then another creature called the Arbitration Council of India was to be established, a body tasked with promotion and encouragement of arbitration, mediation and conciliation and other modes of alternative dispute resolution. The council was to be responsible for maintaining uniform professional standards in respect of matters related to arbitration. So again, by many standards, these were very bold reforms and, in many instances, a first. Now, as to be expected, there were some, complexities with the implementation of the 2019 amendments. Not all of the provisions in 2019 were actually notified or took effect at the same time. And indeed, certain provisions were removed before they could even be implemented. So I suppose the question for all of us and for our esteemed panelists today is, where do we stand? How are the amendments working in practice? And fundamentally, are they actually helping to create a landscape and an ecosystem which provides an efficient arbitration mechanism for end users? So on the back of those introductory remarks, I'll now turn to my panelists and seek to get their views on a couple of key topics that we've pre-agreed. Each of them will give a short introduction of 1 or 2 minutes, and then we'll have a round of questions. So we are hoping to keep this very active and free-flowing as a discussion. And we will, of course, save enough time at the end for your questions. So for those of you joining us, thank you. And please do feel free to contribute your questions, which we will seek to answer towards the end. Now, perhaps, Vanita, if I could just turn to you on the topic of institutional arbitration in India. Would you like to take the introduction on that one?
Thank you. Thank you, Kabir and Paresh, and a very good afternoon to my esteemed co-panelists and audience. Hope you're all keeping well and safe. Kabir, like you said, the arbitration landscape in India today has come a far way from 1996, when after opening of the Indian economy, the government enacted the Arbitration and Conciliation Act. However, there were certain key factors that prevented India from becoming the arbitration hub or the preferred destination, one of them being lack of institutional arbitration, apart from other factors like high costs of arbitration, delays in proceedings, etc. Institutional arbitration does offer the advantages of providing a clear set of arbitration rules and timelines for the conduct of an arbitration, support from trained staff who administer various stages of the arbitration proceedings, a panel of expert arbitrators to choose from to decide the dispute, and in some cases, supervision in the form of scrutiny of awards. So since effective arbitration process can make India a sought-after business destination and enhance ease of business, some of these issues have been sought to be addressed in the last 5 years by the various amendments you had pointed out. Some of the factors that hindered the growth of the arbitral institutions were one, in India, the people still have more faith in traditional ad hoc arbitration, which gives parties greater control over the arbitration process, flexibility to decide on the procedure, etc. This is something that the institutions have to grapple with. Arbitral rules of these institutions were not updated as often as they should have been. Additionally, most institutions' rules did not have provisions permitting accepted best practices as prevalent across the world. There was lack of infrastructure. There was difficulty in assessing quality of the institutions due to lack of information, lack of personnel without adequate knowledge and experience of arbitration, no minimum criteria for inclusion of arbitrators on panels of the institution. So Arbitration Amendment Act has brought about some 2019, though not notified, has brought about some key changes. Some of the relevant amendments pertaining to institutional arbitration, which you have also pointed out, Kabir. One is it now defines arbitral institution. It provides for the establishment of Arbitral Council of India, and it's interested with the grading of arbitral institutions on basis of different criteria, like infrastructure, quality, and caliber. So that is some part of monitoring involved. It is also provided that Supreme Court and High Court have the power to designate the arbitral institutions which have been accredited by the ACI. Section 11 provided for appointment of arbitrator by the Supreme Court or the High Court respectively in domestic arbitrations where the parties fail to appoint. Now, the amended Section 11 entrusts the appointment of the arbitrator in the arbitral institutions designated by the Supreme Court. The amendments also have introduced express provisions on confidentiality of arbitration proceedings and immunity of arbitrators. Further, the 2019 amendment provided for the 8th schedule, giving qualifications of arbitrators, but in the 2021 ordinance, 8th schedule has been removed. However, the qualifications, experience, and norms for accreditation is to be specified by the regulations. Now, all these amendments are yet to be notified. So while the establishment of an arbitral council providing for promoting institutional arbitration specifically, making recommendations regarding personnel, infrastructure, etc., and keeping a check on quality, these are all good amendments which will promote institutional arbitration. There are many concerns that are anticipated to emerge once the amendments are notified. And it would remain to be seen if the amendments should not prove to be counterproductive in promoting arbitral institutions. Thank you.
Thank you, Vanita. I mean, that was a very, very good introduction to the topic, and I think you covered a number of the points that many of the participants were interested in learning about. I suppose, looking more directly in your view, I mean, given that we're now sort of 1.5 years down from 2019, do you think that the changes have actually been successful in encouraging the end users, as you pointed out, to actually adopt institutional arbitration as being, a norm that's more efficient, a more organized way? Or do you think that generally end users are still more comfortable with domestic arbitration? And what's your experience of that?
So the legislative changes focusing on promoting institutional arbitration per se are yet to be notified. Having said that, however, the various amendments in the last 5 years, which you have pointed out, have served to encourage arbitration itself, like ease in enforcement of awards, reduce judicial intervention, and respect for finality of awards, provisions to facilitate expedited proceedings, procedural flexibility. So if India is seen as an arbitral-friendly jurisdiction and becomes a favored seat of arbitration for international arbitrations, at the very least in matters involving Indian parties, this would in any event make the jurisdiction attractive for institutions to establish themselves in India, considering that the caseload would not be manageable by ad hoc arbitration, and especially with the growth in specialized arbitrations.
Yeah.
Especially technology contracts, I mean, personally, I feel where confidentiality and expertise is required, it would promote setting up arbitral institutions. And also, this is evident from the fact that MCIA in late 2016, it was launched. Rules of MCIA provide for international best practices like those adopted by international arbitral institutions. And it has also provided much needed physical infrastructure. Then the shift via the legislative changes, this is also reflected by the positive steps being taken by international arbitration institutions also, which have been investing in the Indian market. Like ICC recently appointed its first regional director for South Asia, SIEC is open to representative offices in India.
Yep.
So encouragement to parties to choose institutional arbitration in the last 5 years, that has mostly been the effort of the institutions themselves by having a clear set of rules, trained personnel, providing a panel of good arbitrators, creating awareness on advantages of institutional arbitration by holding seminars and workshops. So
Yeah.
Yeah,
no, that's good to know. And I suppose in your experience, I suppose on the front end, are you seeing parties adopting more institutional arbitrational clauses? And you mentioned MCIA obviously as being one very well established institution in India. And in what kind of contracts are parties sort of really heading towards institutional arbitration?
So yes, in my experience, definitely there has been a shift towards incorporating institutional arbitral institutions in the clauses. This has mostly been, like I said, due to increased publicity and increased awareness. There is no concrete data as such, that in what type of contracts they are adopting. But however, like I said, in mostly technology-related contracts, where there is a likelihood of alternate dispute resolution, there is likely to be an increase. And there are certain unique challenges that are faced by technology companies on account of global impact of their operations, geographical limitations of a country's legal system, fast-paced transfer of data, and maintaining confidentiality on proprietary information. So all these challenges, I think, can be met by arbitral institutions. Further, in court system, judges are also not familiar with technology. So arbitral institutions, they can have, expert arbitrators. They can provide expert arbitrators. They can help in maintaining confidentiality, ensure neutrality of arbitrators, considering the job.
Sure.
And apart from that, construction sector, power sector, requiring technical expertise, they also choose arbitral institutions.
Thank you. No, I think that's also consistent with our sort of broader experience outside of India, where these, as you mentioned, tech related contracts, particularly because of the sensitivity, whether it's intellectual property or the data, the confidentiality as well. So it seems to be a similar experience. Could I now turn to perhaps Rajendra, one of our other panelists? And Rajendra, I suppose in your experience, you do a lot of work, you lead the team out of Mumbai, and you have a huge arbitration caseload. What in your experience is the current experience of Indian arbitral institutions? I mean, are their caseloads growing? And what do you see as the sort of, major areas for future growth, Rajendra?
Sure, thanks, Kabir. Hi, everybody. Well, so certainly from where things were, there is much greater awareness now about arbitral institutions. Vanita, I think, made all the right points, especially with our newfound friend COVID-19. I think you have no options but for technology. Now, and is the load growing? Yes, I certainly see that the load of the institutions is growing, the role of the institutions is growing, and I think the institutions are also reacting very well. Courts are reacting very well by having institutions administer arbitration even where the clause did not provide. The question really, and the second part of your question is, where do I see this go? If one just takes life back to 20 years or maybe 25 years, people thought India is just Mumbai, Bombay, Delhi, Calcutta, Madras. But as life has shown, India really is in the B cities, the C cities. When one heard for the first time that a group of people from Aurangabad got together to buy 100 Mercedes-Benz cars, I think that is where India really is. And therefore, the key is going to be, it's a no-brainer that, for example, an Amazon arbitration is going to be institutional. I think it's a no-brainer that most bilateral investment treaty arbitrations would be institution governed. But it's only when it will percolate down. It's only when it will trickle down to the smaller towns, which is where there is unbelievable growth potential.
Oh, that's a good perspective. And Rajendra, you mentioned one point, so let me just pick up on that before I let you go and we move on to the next topic, which is what the courts are doing. So again, I mean, as we all know, I mean, arbitration is really part of an ecosystem. You have the legislation, you have the courts, you have the end users, you have the institutions, and I suppose, what role do you see the courts playing in terms of encouraging the use of institutional arbitration? And quite honestly, how do you think they've been doing so far?
So, well, as I said when I was responding earlier, the courts have had MCIA administer arbitrations when the clause did not provide. So I think it's the push towards institutional arbitrations where the court can play a role. Today, where you, for example, have your Section 11 application for appointment of arbitrators, if the dispute is above a certain financial threshold, the court can certainly encourage parties. And on the lighter side, our courts are known to have their own arbitration clauses. I mean, I have had occasions when I've appeared before courts and the courts have said, well, your clause provides for 3 arbitrators, but guess what? I think this dispute should be resolved by a single arbitrator. And with all the gravitas that the High Court judge brings in, more often than not, he's very convincing. So he can also possibly use that same convincing power to say that, well, with the kind of dispute that you have, why don't you take this to X institution, Y institution, because it will give you everything on a threshold. The experience, the technology, the ability to have experienced arbitrators, familiarity with the process, and for a fee which is certainly not a dent. So I think that's the role that the courts are playing, and that's the role that the courts can additionally play.
All right. No, thank you for that. Great. Now, I think we've spoken about institutional arbitration. There's a lot more to cover. So I'm going to move on now to the next topic, which is another very interesting amendment, which was timelines for arbitral proceedings. And again, that was something introduced in 2015 and perhaps then carried over in 2019 as well. And I'm going to turn to another panelist, Percy, to give us the introduction to the topic, and then we'll go around with a few questions. Percy, over to you.
Thank you, Kabir. So there was an amendment in the provision for timeline in the 2019 amendment. As you mentioned, the provision for timeline actually was introduced by the 2015 amendment. I personally do not agree that you can really legislate for timelines, but as you said, some may argue that it was the need of the hour. Now, what this amendment does is it links back the time of 12 months to commence from the date on which the pleadings are completed. So there's a new provision, Section 23(4), according to which the pleadings have to be completed within 6 months of the tribunal being formed, entering into reference. And then the timeline for completing the process of arbitration under Section 29A is said to be 12 months from the completion of the pleadings. Now, this can give rise to some complications, such as the one that I experienced recently, where if the pleadings are completed before the 6-month period that is specified, then whether the timeline runs from the date of completion of the pleading or some may argue based on the language of the section that it has to be 6 months from the date of entering into reference. So these are the complications, but by and large, what this amendment of 2019 does, it extends the time period available by a further 6 months, because the time period now runs from the date of completion of pleadings. Again, in a jurisdiction like India, where courts have regularly held that timeline recommendations are not mandatory, I'm not too sure whether it's possible to legislate for timelines. One has to really look at the reason why arbitrations are delayed. Things like courts insisting on enforcing certain multi-tier clauses, for example, where one or the other of the parties tries to kick the can down the road by taking advantage of that. If the clauses are not very properly drafted, then there'll inevitably be an objection to say you cannot commence because this precondition to arbitration has not been satisfied. And I also do feel that, in the 2015 amendments, it was really the arbitrators who were the rough end of the stick. A lot of the times the delays happen also because of counsel. One of the problems that we have is there is no separate arbitration bar, and you cannot arbitrate after 4 o'clock, after court hours. So these are the endemic problems that are to be addressed rather than to try and legislate for timelines.
Yeah, no, thank you, Percy. I think that was a fair summary of the position, and again on a very sort of controversial topic. Again, in your experience, and obviously we know you sit both as arbitrator and huge amount of experience as counsel. I mean, are these timelines actually working in practice? And again, I know you identified a couple of problems. So, are the parties, playing ball, so to speak, and are the tribunals doing the same in terms of giving, effect to what was intended by the legislation, or is this all just sort of, academic banter?
I think the latter, very clearly. So, I have a couple of funny experiences. So, for example, there was a very well-known, panel constituted recently where, we were running short of the timeline on the second occasion, right? And they said, okay, well, this is the day. So, we must have a hearing on a Sunday, because in case the court wants to know what the hell is going on, you can point to the fact that we are even having hearings on Sundays. So I don't think it is a provision that is taken very seriously. Arbitrators are, of course, very mindful of the timeline, but it must be appreciated. A large number of the domestic arbitration that we have, construction disputes, infrastructure type of disputes, where there are the evidential proceedings itself take a lot of time. And, I don't know whether it is possible to impose timelines on those kind of disputes without having, losing something in the entire process. As I said, the reason for the delay is not that people are not interested in completing the arbitration in time. There are many other problems that need to be addressed before you can start legislating.
Yeah. Yeah. No, and again, I think as you say, that the timelines will work for some cases, they might not work for others, and there will be some cases where just by the nature and complexity of the dispute itself, it's not suitable to impose that kind of guillotine. I mean, are we seeing in terms of practice many applications to court for the extension of the timeline? So are parties sort of saying, look, we can't simply work with this, and one or both parties going to court? Are you seeing that in practice as well? And how are, I suppose, the courts responding to this issue?
Yes, there are quite a few applications after the 6-month consensual period has expired. And by and large, the courts are also, if both the parties are coming forward and saying that there must be an extension and it's required. Of course, the law, mandates that the courts must look into, the reason for the delay. But then again, that's another example. I mean, you see, here we are talking about reducing the role of courts, and now there are arbitration benches which are getting flooded by these kind of requests. So the courts, as long as the parties are ad idem on the fact that more time is required, I think the courts are fairly amenable to that.
Okay, that's good to hear. Can I turn to someone else on the panel? Pramod, one of the mischiefs, I suppose, the timelines were intended to sort of address was sort of dilatory tactics by respondents. Now, do you think that some of the timelines give difficult respondents an opportunity to create procedural objections? So, whether in the form of the arbitration proceedings itself, or perhaps then raise arguments in the enforcement stage? Have you seen anything like that emerge out of this issue?
Well, I think the short answer is yes, they do. If a request for extension of time is not made by both sides, then this can often create difficulties in practice. And quite often, as you know, respondents typically in arbitrations have a greater incentive to stall or to delay an arbitration. And therefore, the need to approach the courts for an extension of time sometimes provides fertile ground for an obstructive respondent to delay the arbitration. And that does happen quite frequently. In fact, without naming anyone, in a recent matter in which I had acted as an arbitrator, the claimant approached the court for an extension of time. The respondent neither agreed nor disagreed. It simply did not respond. And since it was, it had to be served with the application for extension of time, it managed to avoid service for some period of time. And the end result was that it took more than a year for the proceedings to resume. So the original legislative intention was that the entire arbitral process from start to finish has to be completed within 12 months. But if it takes more than a year to get a 3-month extension from the court for a completion of an arbitration, then obviously something is not working well in practice. And the unfortunate bit is that this is not an outlier incident, it is quite commonplace. But I wouldn't want to sound a note of doom and gloom. It's not always the case. There are many positives of the legislative amendment. So I think one aspect is that arbitrators are far more diligent these days in the matters that they take on as arbitrators, because that's an aspect that needs to be disclosed, even in ad hoc arbitration. Of course, that's always been the norm in institutional arbitration. And the second, probably unintended effect is that it has also deepened the pool of arbitrators. When the great and the good find themselves too busy. And I think it is exactly in these kind of circumstances that the institutions have to be lauded. The institutions are always looking for fresher, younger talent to come through. And my experience has been that the MCIA included all other arbitral institutions which handle India-seated or India-related arbitrations tend to look beyond the conventional names of arbitrators for a number of reasons, but I think the timelines is one important factor, and that has only served to increase the number of arbitrators or the pool of arbitrators available to serve in these cases.
Okay, that's interesting, and it's an interesting contrary view that we are actually seeing some light at the end of the tunnel as a result of these amendments. One interesting point that once was put to me was whether or not this might, these kinds of provisions might actually form the basis of a challenge during enforcement, and it'll be interesting to see whether respondents go down the route of raising natural justice issues or right to be heard, etc., if they are forced to complete proceedings in a certain amount of time. But I suppose if there's anywhere in the world that kind of argument will be raised, it's the Indian court. So we shall all wait and see for that for that to be raised soon enough, I'm sure. All right. As we are moving on, Pramod, now you're going to take the sort of mic next on the 2020 Amendment Ordinance. Again, that was sort of the most recent set of amendments, on the back of the 2019 ones. Do you want to take us through the introduction, and then we will go for a round of questions? Over to you.
Sure, happy to do that. Thanks, Kabir. Well, it's actually no longer an ordinance. I think the ordinance was promulgated in November 2020, and an ordinance under the Indian constitutional scheme has a shelf life of no more than 6 months. So the ordinance was in fact replaced by an act of parliament. The parliament voted unanimously to convert the ordinance, which was promulgated by the government, into an act of parliament, and that happened in March this year. The 2020 ordinance and the March Act essentially sought to make two main amendments to the Arbitration Act. The first was to grant an unconditional stay on the enforcement of the arbitral award until such time that a challenge to the arbitration award is decided by the courts. And this is limited to cases where the party making the challenge to the arbitration award is able to prima facie establish that the agreement, the arbitration agreement which formed the basis of the award, or the making of the award itself, is induced or affected by fraud or corruption. The second aspect which was dealt with by the amendment was to delete Schedule 8 and some of the amendments to Section 43, which have proved to be quite controversial, both within India and outside India.
Okay. So, I mean, in your view, I suppose, what was it that provoked this backtracking, so to speak, on some of the aspects of the 2019 amendments? Again, you mentioned the controversy. And I suppose on the round, do you see that as a positive step in the right direction for Indian arbitration?
Well, I think yes and no. I think it's there are layers of answers to it. As far as the 2019 amendments are concerned, it inserted a few additional clauses to Section 43 and Schedule 8. And these insertions received a lot of criticism, both in India and internationally, for a number of reasons. Firstly, the idea of having a government-appointed authority exercising some level of regulation or supervision of arbitration is always bound to be controversial, especially in India, since government departments or government companies are large-scale users of arbitration. The second reason is that such a regime would create difficult tensions with the principle of party autonomy, which, as we all know, is the cornerstone of arbitration and the arbitration process. Third, the qualifications that were proposed for arbitrators and which were enumerated in the Schedule 8, the 2019 amendments, would not permit or allow for appointment of foreign lawyers, or for that matter, appointment of non-lawyers, such as engineers, chartered accountants, etc., in India-seated arbitrations. This would, in my view, have reduced the pool of available arbitrators and also undermined India's ambitions to be a global center of arbitration. You certainly cannot achieve such a lofty ambition by prohibiting the best of foreign arbitrators from acting in India-seated arbitrations. So I think due to these concerns, firstly, the government did not notify these particular provisions of the 2019 amendment, so they were never brought into force. And I think it is also welcome that the government has shown that it's open to receiving feedback, including negative feedback, and undertaking a course correction, or what has often been described as backtracking on the 2019 amendment. And I think that's a good news.
Yeah, thank you. I think that's a very fair answer and a very balanced one. Now, just going to one of the, one of the particular provisions, and I think it's Section 43J of the Act, which provides that the qualifications, experience, and norms for accrediting of arbitrators shall be such as may be specified by the regulations. And again, by regulations, I think these are to be set by the Arbitration Council of India when it comes into being. Again, I think many people have asked, really, is that necessary? And, is there still a tendency to be too interventionist in terms of parties' choices of arbitrators? Again, you mentioned party autonomy being the cornerstone, and then we have provisions like that. So I suppose, do you see this provision as being too over-regulative, if that's the word? And if so, what do you think could be done better?
Well, I'll stick my neck out and I'll say I completely agree with you that, if this is actually, if there are regulations which are very prescriptive, then they would be, it would be controversial, because the net effect would be that it would over-regulate the party's choice of arbitrator. But the good news is that we have not seen any regulations being issued, and I hope Section 43J, which you've referred to, remains a dead letter. Stick my neck out, I would say that the only real qualifications for appointment of an arbitrator, in my view, should be that firstly, the arbitrator should enjoy the trust and confidence of the parties or the appointing authority, and that the candidate's independence and integrity is completely beyond reproach. So there is a fairly robust mechanism in the enactment to ensure the latter. And as far as the former, I think we should just trust the parties to make a good choice, or if that's the choice that they make, then they have to live with the consequences of that choice. I don't think it should matter whether the parties or the appointing institution wishes to appoint an Indian or a foreign national as an arbitrator, and whether they appoint a lawyer, a retired judge, a chartered accountant, or engineer as an arbitrator is really a matter of individual or institutional choice. And I don't think that the legislation should really provide for that.
Yeah. Okay. No, fair enough. That's fair. Rajendra, if I can turn to you now on one of the other aspects of the 2020 amendments, and that was a provision which basically allows a court to stay a domestic arbitral award pending a challenge in circumstances where the court is prima facie satisfied that the arbitration agreement was induced or affected by fraud or corruption. How do you sort of see the courts applying this sort of new proviso in cases of fraud and corruption?
Well, so if I can just also add to what Pramod was saying about 43J, because I'm going to draw from that in my answer to your question. I think the problem always is the foot in the door. So as is the case with a court having an ability now to stay enforcement of an award, And you have to remember one thing, and which is what I always say when I tell people to relate to amendments, I tell people to relate to judicial precedents. This is not going to be tested in the Supreme Court of India. This is possibly going to get tested in a district court somewhere where, and I'm sure most judges know about, the latest judgments of the Supreme Court in the arbitration, in the arbitration law, but most of them don't. And so therefore, such wide clauses are not really a foot in the door. They're actually way beyond. Therefore, in that sense, I think it's a recipe for disaster.
All right. No, I think that was a very frank and honest opinion. Thank you for that. I think we will see how that pans out, but that's certainly one view. Again, it's something which has caught the interest of the community outside India as well, those of us familiar with Indian arbitration. And again, we're all waiting, I suppose, to see how this is actually taken up by the courts and in terms implemented. And as you say, it is going to likely be difficult. Now, I suppose in terms of one of the other related issues to this, right, which is you have the issue of fraud being arbitrable or not. And again, that's always an argument that's raised in the Indian context. Now, the recent India case law does sort of confirm that, fraud, save for the very exceptional circumstances, is generally arbitrable in India. And how do you sort of then deal with this kind of an amendment there, where you've inserted the ability to stay proceedings on the basis of, fraud and corruption inducing the arbitration agreement? Do you think that sort of complicates the issue somewhat? Because on the one hand, you have the court saying, look, fraud is arbitrable. And then you have the courts now having to intervene when they believe that fraud and corruption was involved in an arbitration agreement.
It absolutely does, Kabir. So I would describe this as one step up and two steps down. There were, and because of our constitution, and which is what I think we've inherited from the British, a lot of what is done by the Supreme Court becomes law. And then you have a judge of the Supreme Court who may not be completely conscious of what he's saying. And so therefore, when people started saying fraud is not arbitrable, we really, in that sense, stuck out like a sore thumb. When our respective firms, which is Clifford and AZP, we had to argue arbitrability of fraud in relation to misrepresentation in a contracting evidence. It was an uphill task. And finally, I think what the courts have done is absolutely correct to say that if fraud results in vitiating the arbitration agreement, or unless fraud has a public element, it's arbitrable. And I know I'm oversimplifying it because I'm conscious that,
Sure.
I don't have time to,
Sure,
get
fair
into
enough.
academics.
Fair enough.
But now what has happened is with the new introduction, as I said, it's one step up and two steps down, because you're back again to a first court, an appeal court, ultimately go to the Supreme Court, wait for your appeal to be heard, and finally a Supreme Court judge will lay down what the law is. So it just sets you back considerably.
Yeah, understand. No, I think that's a fair point as well, because it does insert one other aspect there, which you being a difficult respondent would be able to take full advantage of if your objective was to delay and derail the process. I suppose we are where we are. So promote for you, just to end off this line of questions again, looking at this particular amendment, do you think that it really opens the door for debtors to jam up enforcement on domestic awards? I mean, I suppose one more string to their bow if they're looking for a delay strategy.
Well, on this, Kabir, to be honest, I would take a slightly different view. I completely understand where Rajendra is coming from, but I would take a slightly different view. I think my difficulty with this amendment is I don't really understand why it was brought in in the first place. It's really a solution in search of a problem. And why I say that is because I don't think there was ever a specific problem that had actually arisen in the interpretation of the Act, which had to be addressed by means of a clarification or a modification of the law by Parliament. We already have a provision that says that when an application is made for a stay of the operation of the arbitral award, the court can grant stay of operation of the award for such reasons as to be recorded in writing. And the court could impose terms. So the power to therefore stay the operation of an award already existed before this amendment was brought into force. And I don't recall having come across a single judgment where the court actually found that either the arbitration agreement or the arbitral award was prima facie tainted by fraud, and nevertheless insisted that the losing party had to deposit the entire sum awarded by the arbitral tribunal as a precondition for challenging the arbitration award. So if that problem hadn't really arisen, I don't really understand why this amendment was necessary. But having said that, but I think that the amendment was unnecessary. I don't think it really opens a new door for award debtors to stall enforcement of awards. Like I mentioned, I don't think the amendment creates a new avenue for challenge to arbitration awards. It does not reverse the trend which says that fraud claims are arbitrable as a matter of Indian law. The amendment only clarifies that in the event of a court being prima facie satisfied that the arbitration agreement or arbitration award was induced by fraud or corruption, it could stay enforcement of the arbitral award in toto. And I think this was really the position even before the amendment was brought into force. I don't therefore see it as being problematic.
Yeah, agreed. No, I don't think it changed the law very much. It just sort of highlighted the issue somewhat, I suppose, for someone to take advantage of. Great. All right, so we're moving on to the panel, and again, we're reaching our sort of final topic of the day, and I'm going to sort of turn to Rajendra this time to sort of take the baton on the topic of India as a seat. And again, all of us know, India's aspirations to become, leading seat for international arbitration. And I suppose what's important for us to try and do today is see what the 2019 amendments have done and how they've sort of helped or set India back in terms of achieving this. So Rajendra, over to you on this one.
Thanks, Kabir. So I would divide this into two buckets very quickly. The first is, are we saying that India becomes a preferred seat of arbitration like Singapore, where you have two Indians who prefer to have Singapore as a seat of arbitration? That's the first bucket. And the second bucket is, how do we ensure that Indians choose India as a seat of arbitration and don't think of going off to Singapore, London, and wherever else? The way I look at it, I think is we were at a stage where, as someone has said, घर सजाने का तस्वुर तो बहुत बात का है, पहले ये तय हो कि इस घर को बचाएं कैसे. So decorating the house was the second priority. The first priority was to ensure that the house stays, and therefore I think a lot of these changes were brought in for the second bucket, which is to ensure that two Indians choose India as the seat of arbitration and not go away to Singapore, especially for large value contracts. The best example is the timeline is made applicable to arbitrations which are arbitrations between two Indians, even where the seat is India. And if there's an international commercial arbitration, and even if the seat is India, the timelines don't apply. So I think that the intent really is to kind of try and ensure that there is enough incentive for Indians to choose the seat as India. The other very important change that we've seen, and it's right now in middle of adjudication, so I would just make a reference to it, but this whole concept of emergency arbitrators being available. Now you are in a clogged court system. When Pramod was saying that the ground to challenge is already available on fraud, I think the difference is it in a sense accelerates its implementation if it comes in at a time when you are not required to deposit money. And that is because you have a clogged court system. So if you were to choose India as a seat, and if you were to choose an institution which provides for emergency arbitrators, you get the benefit of going to an emergency arbitrator. Hopefully the courts will stick to the argument that, well, it's a Section 17 award. Therefore, it has it can be enforced, it can be challenged, and you have the benefit of going before a tribunal of your own choice, which is again party autonomy. So I think there are steps in the right direction in order to make India a seat of arbitration more for the second bucket than the first bucket.
Okay. Now, I suppose when you look at, and again, this is a fairly broad question, Rajendra, but when you look at the 2015 and 2019 amendments on the round, in your view, has it sort of brought India significantly closer to catching up, for the lack of a better term, with the other major international arbitral seats, whether it's, Singapore, London, Hong Kong, Paris, around the world? Or do you think there's still, some way to go?
So, I think the legislative changes are in place today. As they'll get implemented, as you'll have more and more judicial precedents, there'll be more clarity. That's the platform that India is looking for. So, and of course, at the end of the day, there is always scope for improvement, right? No, nobody is perfect. Nothing is perfect. And certainly not a country of 1.4 billion people. So, so in that sense, I think all the right noises are being made.
Okay, and I suppose when you look specifically at Indian parties, and again you mentioned this interesting point, right? That one would understand typically that international parties doing business in India would tend to choose a foreign seat because of neutrality, so they would want to go to Singapore, London, or one of those jurisdictions. But I suppose you're also seeing a trend in some of the more substantial cases where you have Indian parties potentially choosing seats outside of India. Now, why do you think this is happening? And where are these Indian sort of parties bringing their arbitrations to?
So I think the responsibility in that sense sits with all participants in an arbitration, starting from the arbitrators to the bar, to the clients, and then to the courts. So in that sense, the simplest argument, and we have clients come and ask us these questions very, very often. And in more cases, when there is an international or a non-Indian client and an Indian client, and as all of us have seen, the muscle power of the Indian has changed a lot. So today, you are in a position as an Indian client to say, well, I'm not going to agree to a foreign applicable law. I'm not going to agree to a seat outside India. And there is a discussion. I mean, there was a time when the foreigner would say, forget it. We're not doing this. But now things have changed. And what are the factors that come to a person's mind is simple things like court delay. The whole purpose of arbitration is you want to go away from a system where timelines cannot be accurately predicted. Now, with this in mind, this has also therefore gone to two Indians who are getting into a contract which is not really in that sense an ordinary contract. It's a high value contract. And therefore, there also the temptation is to go to a jurisdiction where the court intervention is minimal, where the courts are very reluctant to interfere in challenges, and where the pool of arbitrators which is available is more hardworking than what you would find in India. I'm not saying former judges are not hardworking, but maybe they are more hardworking, maybe they are more commercial, maybe they are more astute, maybe they are more on the ball. And these are factors which are weighing with Indian parties when they choose arbitration seated outside.
Yeah, I think all of points that I'm familiar with, and I think that must be right. Okay, shall we now take the last two questions on the topic? And Vanita, I know sort of you've been quiet for a while. Let us come back to you because you started off the session. Again, just in terms of your experience, I mean, we've been talking about Indian parties going outside of India. But let's talk about, I suppose, about the reverse, which is, the typical formula being international parties wanting to choose a seat outside of India. Are we now seeing international parties choose India as a seat? And sort of, how do you think that's working out? Rajendra mentioned the muscle power that Indian parties now have in terms of negotiating contracts and sort of insisting that, India might be a seat. Are you actually seeing that, Vanita, work in practice where Indian parties are choosing and successfully getting India as a seat in their contracts? And if so, are they then doing it with the institutions or are they actually doing it ad hoc?
Yeah, so considering the pro-arbitration judgments that have come, and obviously the legislative amendments, so yes, there is an increase. However, the cases wherein India is opted for as a seat of arbitration is restricted to cases involving one Indian party, or the subject matter of the dispute through the underlying contract is related to India. So international parties, I would say, are as such still hesitant in opting for India as a seat of arbitration. But having said that, the efforts being undertaken and through various legislative informants, they would take some time to really, it's only been 5 years. Pro-arbitration judgments have started reflecting in, and the fact that it will take time and things will grow because India in the World Bank rankings, India has ranked 63 of 190 countries and has moved up from 131 in 2016. So even though now they are not still opting, but I think in the times to come,
Sure.
even arbitral institutions are at a nascent stage. So as and when they grow, they would definitely choose India. Thank you.
Yeah, no, I think hopefully 5 years time, if we're having a same discussion, then we will get slightly more. We all hope we'll get different answers, but yes, yeah, time will tell. Thank you, Vanita, for that. Percy, over to you. Again, perhaps the $1 million question, saving the best for last, which is, what further amendments would you like to see to the Indian Arbitration Act to sort of, carry it all the way and to sort of, sharpen the edges, make it sort of perfect? What do you think realistically, is achievable and in terms of the priority amendments you would like to see? Percy, you're on mute. Sorry.
There you go.
Thank you.
So the less legislation you have, the better in my view. But there is room for clarification. So one of the points, of course, is, as Rajendra mentioned, this absurdity about Indian law doesn't recognize emergency arbitrators. First of all, I don't think that is true. So it needs to be clarified. That's all there is to it. There was I think the 246 Law Commission had spoken about, giving recognition in the statute to an emergency arbitrator. And then it didn't happen. Now, does that really mean that the statute bars emergency arbitrators? I mean, when you talk about party autonomy, and I think Rajendra touched upon this. So I would like to believe that the amendment did not happen because it was not found to be necessary in the first place. And now we have this, huge dispute going on. So I think that needs clarification. And then there are a couple of other things. So, when you look at timeline and things like that, look, I am a firm believer about arbitrability being one of the issues that we should settle very early on. So, the introduction of prima facie, it was there in Section 8 and then, 45. So the court at the time, it is making a reference, and also possibly under Section 11, when it is appointing an arbitrator, to what extent does it go into the issue of arbitrability? Now, I know that there is Section 16, and we follow, the doctrine of competence, right? But consider this. If there is a very important issue about whether the dispute is arbitrable or not. I mean, we are all used to talking about some frivolous challenges that take place, but presume for a while that a party has a very significant point to make. And the court initially, while referring them to arbitration, does not cover that, or covers that only prima facie. And again, what you mean by prima facie is, again, a very good question, right? Then it goes to Section 16 before the panel. Now, in India, most of the Section 16s are not, there's no, immediate ruling. It comes out only in the award. So you go through the whole process and then you have to challenge it. You have to challenge it as part of the challenge to the award. So, I don't think it is the best thing to do. I think courts should be able to decide, if it's a valid question about whether something is arbitrable or not, then it should be decided upfront. Of course, whether there is any such thing as arbitrability or not is a separate issue. Some people have the view that everything should be arbitrable. That's a separate topic altogether. but at least on the Indian law, this should be decided upfront rather than waiting, running the course and then, coming to the courts to decide that issue. I think it's just a waste of time and money.
Absolutely. Great. So we're sort of coming to the real tail end of the session. I'm getting prompts from the organizers that we're running into the last 5 minutes. And again, because we started 5 minutes late, I'm going to take a bit of liberty to give all of us a bit more time. Percy, one last topic to cover right at the end, and it's really a single question on the Arbitration Council of India, probably one of the most remarkable, and I can see you shaking your head already, but controversial, concepts to be introduced. Again, probably a first for the world happening in India. What in a nutshell is your view on it? And then, happy to sort of go around the table with the panelists. What's your view in it? Good, not good, serious, is it a serious misstep, or do you think it is something that India needs to sort of, deal with the unique challenges it faces?
Distressing. So if you look at, how this emerged, right? I mean, it was in the Justice Sri Krishna report, but in a very different form. And I think the genesis of that is the fact that in India, every lawyer and his dog has an arbitration institution, right? And the question is, see, when you talk about LCIA or Singapore, right? I mean, it's Singapore jurisdiction, London jurisdiction. In India, the feeling is that you cannot really pin down that there will be only one or a handful of institutions. So the need was felt to provide a system of grading of these institutions, which is fair, right? I mean, you can do that. And who would do the grading? So therefore, the idea of Arbitration Council germinated. Now, if you see the Sri Krishna report, the composition of the council is very different. There was supposed to be, in fact, eminent international practitioner on the council. That's not how the statute reads. And then you find two government officials. If you see the mandate, I suspect that if it ever does come about, it will really be a seminar body, to be very honest. And then, one of the things that you read is norms to ensure satisfactory level of arbitration. I mean, how does a council decide what are the norms? So this is something that needs to be relooked at very quickly.
Yeah, no, certainly one of the more controversial amendments. And again, turning now to just the last few comments that I'll make, and sort of taking some of the questions that we've received from the audience along the way. Thank you very much, everyone, for sort of their contributions and putting in the questions. We've received one specific question, and Percy, picking up a point that you made relating to the grading of institutional arbitration institutions. Is this really a good idea? How does it work? Pramod, can I turn to you for your views on this one? I know it's a bit sort of a little bit of a hospital pass, but an interesting one, I think. You've obviously been, very familiar with institutions inside of India, outside of India. You sat on the LCIA as well. You're involved with the HKIAC now. So, what has been the reaction to being graded by the Arbitration Council of India, and how do you see this whole concept working, if at all?
Well, I'll be quite candid about it, as Percy was. I would endorse and echo that adjective. It's distressing, and I speak not from the point of view of any arbitral institution, but in a personal capacity, and it's simply unworkable. How would you really expect an arbitration council comprised of government appointees sitting probably in a building in Delhi to rank and grade an arbitral institution? Because an arbitration is often only as good as the arbitrators, or the kind of assistance that the arbitral tribunal gets from the parties and the council before it. So why would you then fault an arbitral institution for the sins of the arbitral tribunal and incompetent arbitration council? How would you actually implement such a clause? The second aspect is there is a previous provision which provides that arbitration is supposed to be confidential. Then what would be the data that an arbitration council would use to determine whether an arbitral institution has done a good job or not? In practice, it is simply unworkable. It will be information or grading on the basis of incomplete data, maybe biased data provided by a recalcitrant losing party, especially given the government is likely to be a party to many such arbitrations. The fact that you have a government appointed body or a set of people to do this exercise would not inspire much confidence in the process. And I really hope that it remains the way it is, which means that it's there in the statute book, but it's never brought into force.
Thank you. No, thank you very much, Pramod, for those final thoughts. And again, thank you again, everyone. Vanita, Percy, Rajendra, Pramod again for sort of, a very, very engaging and very, very enlightening session. We've received lots of positive comments in the Zoom chat that I'm looking at. We've also received one comment saying, please, 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 you've already gone past time. Can you please end the session now? So thank you very much again to the panelists for all your contributions. And again, also to the audience for joining us. I know there's another session coming up after this. So wish you well for the day. And we hope to catch up with you throughout the week. Thanks, everyone.
Thank you, everybody. Thank you for all the panelists, and thank you for everyone who attended the session. We had at some point of time over 160 attendees for the session. We have, of course, taken a lot away from all of you in terms of what you've discussed. A lot of food for thought, lot of things for us to consider about how practically the amendments are kind of a superimposition over and glossing over some really significant issues, and where are the areas where we need a lot more clarity. And I think all of us can go back to our respective practices and think about those and see where we go from here. And thank you for everybody for your time. This has been a great learning experience to everybody to hear from you and your thoughts.